Civil litigation this week, as we discussed just the other day, we're going to talk about the complaint. Now, you should already have a good idea of what a cause of action is, what that term means. If you don't, go look it up. But a complaint states the cause of action. Pleadings have to have numbered paragraphs, and we're going to talk about that. You should understand jurisdiction and venue by now. If you're only in, and that only applies to one or two of you, I think only two in this class are in intro for the first time. We did discuss that for the first time in intro, but the rest of you have had this in other classes, and even you two, I believe, are also in research, so you should have had a good presentation of jurisdiction and venue by now. You'll also be able to differentiate fact pleading from notice pleading. Illinois is a fact pleading state. You already know the usefulness of form books. Hopefully you've been in the ICLs. Hopefully you've done the things I asked you to do before this week. So you have a good idea of where to find examples of complaints. But after we have our discussion here in class this week, you'll understand that the complaint is where we ensure our client's right to trial by jury. And if we don't, that right is waived. You should know the purposes of a summons and the difference between in-hand service and abode service and what abode means. And if you don't know, ask Siri real quick. There's a vocabulary to complaints that you'll learn with experience, but I don't want it to be the first time you hear these terms when you're out there in an internship or practice. So know that joinder of parties. It's the right of two or more plaintiffs to pursue common claims in one lawsuit. It's also the right to file one lawsuit against two or more defendants. Often we have multiple plaintiffs, multiple people involved in a car accident, for instance. Could be multiple defendants. The Murray-Baker Bridge is now closed, but it'll open up here. I believe it's supposed to open up in November. Usually, a couple times a year, there's a crash on that bridge, typically where people exit on Washington Street there, typically because people are coming in to go to work and somebody doesn't pay attention and there's a multiple vehicle rear end accident. If you're in the first vehicle and the first car behind you rear ends you, the car behind that car rear ends them and pushes that first car back into you again, and then another car and another car and another car, who's responsible for your injuries ultimately? It may be that you sue all 5 other vehicles, or drivers of all 5 other vehicles, and then some of them may be suing each other because they may have injuries. So we join parties when we have one incident that creates multiple parties and results in a lawsuit. The term counterclaim and cross-claim. You should know what both of those two things are. A counterclaim is a cause of action filed by a party against an opposing party in a responsive pleading. So usually it's the defendant who comes back against the plaintiff and alleges some action by the plaintiff. So in other words, the defendant, in response to the plaintiff's complaint, may answer that complaint and then file a counterclaim. And in that counterclaim, it looks just like a complaint, but the parties listed as, now flipped. The defendant who used to be on the bottom in the caption is now defendant counter plaintiff versus the plaintiff counter defendant. That's different than a cross-claim. A cross-claim is a cause of action filed by a defendant against a co-defendant, typically alleging that the co-defendant was solely or primarily responsible for the action. And that would read defendant cross-plaintiff versus defendant cross-defendant. So it's defendant against defendant. Also a unique situation. Now, complaint. A complaint is the formal statement of a plaintiff's cause of action seeking a legal or equitable remedy. Remember, we talked about law and equity against one or more defendants. And when filed with the court and served on those defendants in the required manner, it commences the lawsuit. The complaint is the birth of the lawsuit. So a formal statement of a plaintiff's cause of action or causes of action, because sometimes you have multiple claims, seeking a legal or equitable remedy against one or more defendants, which when filed with the court and then served on that defendant or defendants in the required manner, successfully commences a lawsuit. Now in Illinois, actions are commenced by filing the complaint pursuant to 735 ILCS 5/2-201, which provides that a complaint sets forth who the parties are and advises the court and opposing parties of the plaintiff's cause of action. It requires that the complaint must be clear. It must use clear and concise language, and it has to contain a prayer for relief. Now, for that information, see generally Article 2, Part 6 of the Illinois Code of Civil Procedure, but specifically 735 ILCS 5/2-601 through 2-614. And I would urge you to have that information in a window available on your screen or printed out and available to you while you're trying to draft your complaint this week. A complaint must contain substantial allegations of fact. I said earlier that Illinois is a fact-pleading state. To state a cause of action, you have to allege substantial allegations of fact. That's from 601. Similarly, all pleadings must contain a plain and concise statement of the pleader's cause of action, counterclaim, defense, or reply. So it applies to all of those things. And you know what a counterclaim is now, right? Defense, replies, we'll get to that. That's under 603. The Illinois Supreme Court has held that a complaint is deficient if it fails to allege the facts necessary for recovery. Again, focusing on facts, you have to allege sufficient facts necessary for recovery. That's Chandler versus Illinois Central Railway, Supreme Court case from 2003. The complaint must set forth the ultimate facts needed to prove the claim, but not the evidentiary facts which tend to prove the ultimate facts. So in other words, and you'll hear me say this, and probably in response to drafts that I look at or that you ask me about, the mistake that people tend to make initially when they're first learning to draft a complaint is they think that they have to allege all the facts like they're producing evidence, like they're arguing or making their final argument about why their client should win. That's not what the complaint is for. It just has to set out the ultimate facts needed to prove the claim, but not the evidence. It has to put the other party on notice with the facts of what the cause of action is, what's alleged that that party had done. Those separate factual allegations should be arranged in separate and consecutively numbered paragraphs. That's pursuant to 603B. A complaint which does not put the defendant on notice of the facts necessary for the plaintiff to recover fails to state a cause of action. For that, I cite to you the Supreme Court case of Gonzalez versus Thoric Hospital, a 1991 case. Each count of the complaint must state a specific prayer for relief. That's under paragraph 604. Relief may be pleaded in the alternative, and we'll talk a little bit about that in class. Except in cases of default, the prayer for relief does not limit the relief the court may grant, but the court must protect adverse parties against unfair surprise when granting relief that is not requested in the pleadings would be surprise. Now, we've talked a little bit about punitive damages. And you should remember that punitive damages should not be pleaded in a complaint. Don't put those in your complaint, please. Punitive damages are not sought to compensate or make the party whole. They're sought to punish. A party seeking punitive damages should file a pretrial motion and request a hearing on the applicable, or whether punitive damages are applicable, under 604.1. And the court should allow the party to amend the complaint to plead punitive damages if the party establishes a reasonable likelihood of proving facts at trial sufficient to support an award for punitive damages. So don't put those in. Those are rare cases. And know that you have to go back to the statute, the Code of Civil Procedure, that section. Talk with your lawyer. If you get one of those cases, let me know about it, because they're far and few between, and I'd just like to know about it. I'd like to follow your case. On the slides, I give you some examples of captions, and we talked about captions, and many of you have dealt with and drafted captions, both in class and in internships and in work. On the first slide, it shows a federal court caption. The court's identified at the top, case number, the parties to the left, and then it states what it is, the document, and it gives a date. That's one format. The next slide provides another format. A document that I posted on Blackboard provides an Illinois format. Anything you file in court has a caption. The caption identifies the court where you're filing it, the names of the parties, the roles of those parties, plaintiff or defendant, the title of the document, and then if there's a case number that's already been assigned by the court, that case number. Now, a complaint does not have a case number until you file the complaint. The clerk assigns your case number, so your complaint, when filed, will not have a case number. Let me repeat that. Your complaint, when filed, will not have a case number on it. The clerk will assign a case number at the time your case is filed. Everything after that point should have a case number assigned. The case number should be listed on the document. There's an example of the signature block. Now, to be clear, certain things have to be verified, which means that the client must sign. The client must read and verify that the facts as alleged are true. That's true with divorce petitions, as an example, as some of you know from having completed family law. We're pursuing an auto case. The lawyer can sign the complaint in the auto case. Now, you could have the client sign as well, and some lawyers do that. When you have the client sign, it's called a verified complaint. Complaints and pleadings offered on behalf of a corporation or those in certain types of cases, like petition for dissolution of marriage, are required to be verified. Verification is when the plaintiff or its agent verifies a complaint by attaching a page at the end containing a statement under oath that the plaintiff has reviewed the complaint. Regarding the allegations to which the plaintiff has personal knowledge, the plaintiff knows or believes them to be true. Regarding the allegations to which the plaintiff does not have personal knowledge, the plaintiff believes them to be true, and based on specified information, documents, or both. So in other words, verifying those things that are in the complaint to be accurate. There's two alternative sequences for service of process. In the federal and most state courts, including Illinois, you file your complaint with the court. You have a summons and a copy of the complaint served on the defendant, and then a return of service is filed with the court. Now, in some states, the sequence is have a summons and copies of the complaints served on the defendants, and you file a summons, original complaint, and a return of service with the court. Focus on what's required in Illinois. In federal courts, you file the original complaint with the court. You have your summons and a copy of the complaint served upon the defendant. After service, you file your return of service with the court. Now, service of process in Illinois. In most types of civil action, service can be made by the sheriff of the county in which the case is filed, or by a court-appointed process server. You know, my preference, I represented the Sheriff's Department union, so of course I respect the Sheriff's Office and what those folks do, but they had a large volume of things they had to serve because they're also serving, subpoenas to get witnesses to come and testify in criminal cases, all sorts of things. I always used a private process server. They got it done in a quicker manner. They were typically just, better at getting things done in a shorter period of time. And then when you had a hard service, somebody who was trying to avoid you, they always seemed to be able to get that person as well. They put in a little different effort. And they weren't typically driving around in, a vehicle that looks like it was a squad car, which some people you're trying to serve may notice and try to avoid you. In Cook County, the original service must be by the sheriff. Again, specific rules. The service of summons shall be made by personal service, leaving a copy with the defendant personally, or, if you can't leave it with them personally, by substitute service, leaving a copy at the defendant's residence with the family member or a person residing there at that residence who is at least 13 years of age. And you leave it with information as to its contents, and then by sending a copy by mail, confirming that you left it with this person who's 13 years of age or older. That would always scare the heck out of me because you don't get a lot of actual valuable mail these days, but we still did when my kids were that age. And there were times when I found something that somebody had left for me, sometimes important documents somebody had delivered to my house. I'd find them behind the couch or somewhere because one of the teenagers took the item at the door. You need to find a copy or an example of a Peoria County civil summons, because you're going to need to turn that in with your complaint. Now, to speak about forms for a minute, most court documents look alike. They have the same parts, same expectations, because that's what the Code of Civil Procedure and the Supreme Court rules require. We've talked about forms. There are always examples available in the law office. So those of you doing internships and employed in law offices, we've already talked about, some of you have some of these types of civil litigation forms in your office. Use the forms as examples, as a template to assist you to apply the facts of whatever your case may be as you draft your complaint. Now, I'm going to provide you with an example, a form, something you can look at and work off of. Obviously, you change these things up to fit your need, but what you come up with in the end should have all the same parts, especially a caption and a signature line. Now, you have an assignment to draft a complaint, and it's a draft of a complaint. To be clear, for those of you who I'm less familiar with some of the terms we use in the law, most things we create, we have multiple drafts for. And those multiple drafts get reviewed by sometimes multiple people, until we get to what we call the final draft, the document that's going to be filed. It's going to go to someone else. For this week, you're creating your draft, but it should be a draft that you've actually gone through 1 or 2 times, maybe more. It should be something that you believe is right there and ready to be final. It shouldn't be some thrown together in a half an hour document. It should be the document that you would present to me as your supervising lawyer, that you would propose be the document I approve to then go to court and be filed. Use forms as examples to make sure you have the included parts and you've used the proper format. Be sure you create a proper caption. It includes proper names. Occasionally, documents will get filed with the wrong client's or the wrong party's name, because somebody was using an example of some document from before and just failed to make that correction or change. How embarrassing, and how would you feel if you were paying for that service? Remember, paragraphs must be numbered. Look at the examples. More importantly, look at the statute and what it requires. Your complaint must include the elements we've discussed multiple times now for this type of case, a negligence case: duty, breach of duty, proximate cause, and damages. And it must comply with the law we've discussed today and in the past few weeks. Now, when you look at the example that I'm providing, you'll see the allegations of duty. You'll see the allegations of breach of duty, proximate cause, and damages. And you have to spend some time working on your negligence allegations, as we discussed in class, the Illinois Vehicle Code-based allegations. And if you did that legwork as I asked you to, you should be okay there. And if you didn't, you're going to be playing catch up, and it's going to be a little more stressful for you this week. That's what we're covering this week. That's the assignment, and we'll discuss it in greater detail, or answer any questions, I guess, more so when we review or start talking about the drafts of your document and discuss what you came up with from the Illinois Vehicle Code.